think we all agree that the ECN is really a unique success. I would go further and say that the ECN is a model for other areas of law. For example, the fact that the Commission, in terms of the ECN, cannot only tell a national agency what to do, but that the Commission has to take up the case for themselves if they want us really to change our approach, is something that provides for a clear division of responsibility, something I find very good with in comparison, for example, with the telecom sector, where national agencies can be advised to act in a certain manner. So from this point of view, I really think that the ECN is a model and a unique project. And if I tell other people, parliamentarians and others, how far integration has gone in the ECN, I always see a certain amount of astonishment what can be reached in a certain sector of law and a sector of policy. We have talked a lot about stimulation for the future, and I think that is an important thing after 10 years of Regulation 103. But if you want to look for stimulation for the future, I think you're very well advised to take a close look at reality, at the presence, and to take a close look at the deficits that we might have within the ECN in order to know what we should do better in the future. And I will take a very practical approach now in my little presentation with regard to the procedural rules, with regard to fines rules. As I said, Bruno has mentioned a lot of things already in this area, but I would very much like to take a very practical approach with the question, can our enforcement be more effective? The one question, and the second one, should we be more transparent for companies? So let us do a little thought experiment. Imagine that you are the director for Europe of a company that is active worldwide, plus active in very many European countries. And one morning, very unpleasant news start coming in. Your subsidiaries in France, in Italy and in Germany inform you of uninvited visits by Commission officials, by officials from the Autorità, the AGCM and the Bundeskartellamt. And soon it emerges that the officials from these agencies, from these four agencies, they have not come in for nothing. Your local salespeople have been involved in anti-competitive contacts with their respective national competitors. And what the authorities have found in the three different countries looks somewhat different. In France, they have found evidence for a strictly organized national cartel. Sales quotas, compensation payments, supervision, everything. In Italy and in Germany, the situation is a bit different. They have found copies of emails which prove a few more limited bilateral discussions on prices between your subsidiaries and their specific competitors. The product that you sell is not traded much across borders. Markets are clearly national. And of course, you as a CEO, you summon your lawyers now. And you have questions. Well, who is actually prosecuting us? Is it France? Is it Germany? Italy? The Commission? What is our defense strategy? And your most important question as CEO is the question for the worst case scenario. What about the fines? What can happen with regard to fines? And you find out that you might have very highly paid lawyers in front of your eyes, but they cannot provide you with very clear answers. They tell you that at this very moment, it looks very much like the Commission is the one that is prosecuting your case. But that can change. The Commission may decide not to pursue the case further. After all, national markets are involved, and what they have found in the various countries looks quite differently. In that case, your lawyers might tell you, the Commission will ask the French, German and Italian colleagues if they want to take up the case to go for their respective territories. fine, you say. May not be clear who is going to prosecute us, but whoever takes up this case, it doesn't matter so much in terms of what we do now and in terms of the outcome, right? At this point, your lawyers look a bit awkward. They tell you that in terms of the defense strategy, with regard to your right to remain silent, the privilege against self-incrimination, things are not easy for the time being. You learn that if the case stays with the Commission, they will likely come back to you and compel you to give additional information based on the papers they have found during the dawn raid. In France and Italy, they would proceed probably in a similar way. Things look much better if you are under scrutiny by the German Bundeskartellamt, because in their procedure you have to provide nothing. A big difference. Hearing about the maximum possible sanction, that adds to your confusion as the CEO of this company. On paper, the fining rules of the Commission and the national authorities, they look quite similar. Fines up to 10% of the last annual company turnover. A lot of money, but easy to understand. So you think. Because it emerges that the different authorities have a different understanding of the rule, shaped by their respective courts. For the Commission and the French and the Italians, the 10% rule is what they call a cap, already difficult enough to understand. The Germans, again, are the odd ones out there, because they say that the 10% rule is not a cap, it's the legal maximum of a range within which the authorities has to place the proper fine. At this point, as a CEO, you don't understand very much anymore of what your lawyers might tell you, but you understand that there is a big difference in how the fine at the very end may be imposed. Finally, you also learn from your lawyers that whether your parent company can be held liable also depends on the fact who takes up this case. The Commission, the French and the Italian authorities impose fines against undertakings. So basically all entities under joint control are part of that undertaking. So they would impose fines not only against your 3 subsidiaries in Europe, but also against the entity of your group. The Germans, again, follow their own path, which is much more in the liking of you this time, because they will only be able to impose fines against the local subsidiaries that were directly involved. And they can only go after the parent entity if they can prove that there has been a breach of supervisory duty, which is very difficult at times. So I think we should leave our CEO at this time here in a likely status of complete confusion. What is going to happen next? And I think we as enforcers should ask ourselves at this point, is it okay that we put undertakings in this position where pretty basic things, in fact, about procedures directed against them are pretty unclear? Or is it not a matter of procedural fairness that we move in some convergence of procedures? I think harmonizing our procedural rules is an imperative of effective enforcement. But we also know that the ECJ has told us that national procedural rules must enable NCAs to enforce effectively. And we know that the courts take that serious. They have been looking into any details of national rules. In last year's, in the Schenker judgment, the ECJ prescribed in detail to the Austrians the circumstances under which where they may refrain from imposing a fine. And already back in 2010, the courts told the Belgians to introduce a right for the authority to defend their cases in court. So what I fear a little bit, if it's not us, the Commission, together with the national competition agencies, together with the national legislators, if it's not us who goes for more convergence in the area of procedural rules, it might be that the courts will go for more procedural convergence. And I think nothing against the courts, but I think that is very well placed with the authorities and with the national legislators and with the Commission as well. But harmonizing is also about providing clarity to companies that are active throughout the European Union and who can expect predictability when it comes to the infringe of the rules and the consequences. And I firmly believe that the flip side of flexible case allocation is that the ECN should provide comparable treatment of cases within the ECN as well, and that it should provide predictability in this sense as well. So I think we all agree that such court scrutiny would take away much more of the flexibility that the ECN provides today, if the courts ever have the idea to look into the fact of case allocation, given the fact that our procedural rights are so different as they are today. So I think, to conclude, harmonizing our administrative decision-making tools plays a big role in regarding the effectiveness of our agencies, and I think the Commission is very right to emphasize the importance of what I would label the basic administrative decision-making toolkit. All our ECN authorities should be able to adopt prohibition decisions, commitment decisions, interim decisions, according to somewhat comparable rules. I think that is a very important thing. But I also think if you want efficient and transparent enforcement, fines rules are even more urgent, and there is even a more urgent need for harmonization in this respect. They also play a vital part of every enforcer's toolkit, if not the most vital. And when punishing companies, we also intrude most deeply in their rights. So we have the greatest need for clarity here. So my call today would be to let us give some priority to reaching a consensus in the most basic questions of how we impose fines in European antitrust and making that consensus binding for member states. I'm pretty much aware that this is not only a task for the European Commission, because the one that is needed here are the national legislators. But we should make clear that there is a political responsibility with the national legislators, maybe together with the Commission, to go for that aim, to go for that target. And I think if we make that clear, we might help to build some understanding in our respective capitals, in the respective member states, that we need that response, that we need this convergence in this area for the credibility and the perspective of the ECN in the upcoming years. Thank you very much.